wiase mu ayewe se woni obi koye bone na se chese nipa kro na ya nchewa menya wa adwen se woni de nyame kopon aye de edi wo ho afofie de enti na me kasa eye Richard Jakpa ho sensem na me eka ho asem na isi ade court decide ni 5th century Richard Jakpa okonkoda ye fiase ye fie polypoly 50 years edi onu na abusiafo another name bia be pop up and nipa ni din pie free mu ye wura Sammy Gyamfi Richard Jakpa ebo ni bi so no so kanesem no bi tene oni Richard Jakpa na ekwa kodem ewo efiase anya asem keto omu chese room number 21 eho omaje eye omu prison words aje se eja obi aje ni jesa omu kwakobo ya sambre ne kotisi mu chiwu
proceedings. I just say every other be a judge na aye biano yen twen so na all the accused persons jumadi bia on person mu di bia no yenya omo na omo nyi say jumadi na omo person mu di no now eno na the office of the attorney general on also edinity ko tum no say mo ankro na mu di on pene mamo na mamo file applications we national court share more family disrupt to case no. Now the office of the attorney general and so the application to mo na also application mo go to mo also ensemo omre to journey almost say affidavits filed in opposition to the applications before a high court in Accra that the accused persons are bent on using any means necessary, fair or foul, to abort their legitimate prosecution for crimes committed against the Republic must not be aided in that illegitimate endeavor through a grant of the instant application. Just said the office of the attorney general so say some no make kan no boa o ma di bone e wo se do mo famara kwan so ni some o mo kan kan di ni nyina so bia nti ni kwan se court no yam ya do ma wo chena no ono so ejine. Now the office of the attorney general also affidavit in opposition no it avers that it is in the public interest that the case be brought to a firm conclusion based on the credible evidence before the courts. In the particular case of Dr. Forsen, the affidavit in opposition argues that continuing his prosecution to its logical conclusion will uphold the principle of equality of all persons before the law and defeat the perception that the powerful and politically connected can get away with crimes on account of undue pressure and false allegations. As I said, the office of the Attorney General still maintains, say, the sitting trial judge has already established a prima facie case against Forsen Richard Jakpa. So, omo won sem also be yano. Ninti no file a statement of no case or bototuni no. Say evidence here, the arbitral court no dia dance here. Say letters of credit are issue here. Car somebody by say ambulance. You rejected no Ministry of Health. It is clear say there has been a certain kind of loss to the Republic of Ghana. The office of the Attorney General in their affidavit in opposition and was stating clear. Says a court no etie in someone Sammy Gyamfi to force no lawyers say they should conduct a mistrial on chance for find judgment to some state proceedings now. The Ghana for adjoining in say if you are connected politically there anyone say intimidate say the Mahama de betu so munya to force in case now. Otherwise, the minority will not comply in the business of government. And I just say, yeah, you know, correct. So the trial judge, Justice Efiase, the office of the Attorney General, also affidavit or file, and said she should not accept a yes applications here on Monday Abbey. Now, same way now, the Aquaco Faba is leaked tape recordings and Semia, the NGC is alleging, say the Attorney General. And Richard Jakpa Eddie Komo say on can be to implicate at force near finding Congo Tum into professional misconduct or criminal trial cosono and Attorney General Eddie for it was say a sibling now lawyers from the opposite side and Romano to San Simbuimo Professor Kwame Jan a lawyer ni Papa Brenimini Kesiepa and one lawyer from the NDC side lawyer Pia Omunina Adjuna Kwadrin Krumu on this same issue. Professor Kwame Jan states categorically clear, say the office of the Attorney General enye boni bia so na Richard Jakpa din komo. And komodi ne kosom there was nothing in the shape of implication and now force Richard Jakpa say one can bibi enfentia Iura Forsen. Now lawyer Pia and so on the NDC side so chere say ono no die idea we are no as party for you no hu nyina so bi omo because tape na mo de aba no one afei na mo de court it is going to be tested on two things based on relevance. How relevant is this audio recording in the case before the court now? Ebeka ya no na justice fi asara se mutube kan so no do mo kekan de onte niam e won ni mo court ho e no de be ye adwuma. That is number one. Number two, I also say it is going to also be tested on admissibility. Admissibility is your begia to moi. I just say I'm passing through certain tests. I just say I shim and who say I'm tape no original. In the election petition case, where MPP present here over 11,000 pin sheets. On the case of admissibility, the test for admissibility, no, your KPMG audit, I'm a ye free mo and sana. The catch, you know, you have to admit it, and you should not court. In the same way, that audio must be tested on the basis of admissibility. And to win yes, I am a then I'll file supplementary affidavit application. Say, young conducting mistrial, young granting injunction, any stay of proceedings. Tomorrow promises to be a very, very, very eventful day in this ambulance case trial. Now, when we call in lawyer see or manu this concerning this new development in the Antoforsen case.
Investigating a crime or suspect that a crime may be committed, they will go to a court of competent jurisdiction and seek leave of the court and obtain same and tap into your communications with leave of a court of competent jurisdiction. In that situation, admissibility should not be a problem. In other situations, our law, if you go back to our evidence decree, the evidence decree, which is now the Evidence Act, because of the Statute Law Revision Commissioners Act, is one of the best pieces of evidence decrees in the world, or evidence legislations in the world, because the drafters, led by a late Court of Appeal justice called Justice Ofori-Boateng, famous judge, they studied the evidence laws of almost every civilized jurisdiction and tried to find out what is the best practice before they created our own system. Now, in American jurisprudence, there's a principle which is known as the fruit of the poisonous tree. It's one of the principles that applies in the law of evidence, which says that where a tree is poisoned, the fruits of the tree are also deemed to be poisoned. In non-legal format, it means that if evidence has been collected in a way as